beginning procedural method. Okay, so I do see that the prosecution is team code 1 and that the defense is team code 3. And if the team can go ahead, normally you would provide us a copy of your trial roster. At this time, why don't can the spokesperson for each team go ahead and step up and let us know who's on your team and what role they'll be playing?
Your Honor, would you like us to put this in the chat for spelling's sake, or would you rather me just say it out loud?
You know, I think for spelling's sake, why don't we go ahead and put it in the chat just so we can make sure everybody gets the points they need to get.
Okay, thank you.
And I haven't seen anything pop up in the chat. I don't know if you're still writing. All right, and so, and again, I know this is somewhat of a unique situation. So I hear, or I've received a chat then, it looks like from Miss Holland. And then I received a chat from Miss Cruiser. So it looks like Miss Cruiser is prosecution. Miss Holland, is that defense side then?
Yes, Your Honor. And my co-counsel Cindy Nguyen also put the roster in the chat.
Okay. And then Miss Cruiser, just to verify, the order at which you listed the attorneys, is that the same order at which we will see them present today?
I can correct that order. I placed them in order of opening, middle, and closing arguments, but I can place them in the order of the direct examinations as well.
All right, I just want to make sure all judges are able to identify who's doing direct examination, who's doing cross-examination. So I'm just going to clarify it before we move on. I have from the prosecution from Mr. Cruiser that Marissa Ross will be opening this morning.
Yes, that is correct.
And then Desmond Decker will be
direct examining Kyle Kuzak.
Okay. And then you yourself, Mr. Cruiser, will be direct examining the second individual?
Blake Van Owen and providing the closing arguments. Marissa Ross will be giving the direct examination of I apologize, of Kyle Kuzak.
All right, and we've got a direct of the third witness. Who's giving that?
The third witness will be, I apologize, Desmond Decker, giving the direct examination of Alex Fuentes.
All right, and who's giving the direct of the first witness?
So sorry, I'll go again in order. The order of witnesses will be Desmond Decker giving the direct examination of Tanner Moore, Colby Cruiser giving the direct examination of Jordan Markowitz, and Marissa Ross giving the direct examination of Kyle Kuzak.
All right, and who's All right, we'll get to, and who's closing? You indicated Desmond Decker is closing.
I will be closing.
Thank you. All right, and then for cross-examination, I think we should be able to follow from there, but we'll double check at the end and make sure we are good with who is doing what. All right, moving to defense side then. Thank you, Mr. Cruiser. Do I have then Ms. Wen is opening?
Yes, Your Honor.
And then also crossing. All right, and then directing Becker. Is that correct? Okay. And then Ms. Holland, you are crossing Cifuentes and directing Perkins.
Yes, that's correct, Your Honor.
All right. Raina, and I apologize, it cut the name a little off. Is it Hayden?
Hilden, thank you.
Hilden, thank you. You're closing as well as crossing Kuzak as well as directing Van Owen.
Yes, Your Honor.
All right, and then Sarah Mazur is Van Owen. Perkins is, okay, Becker. All right, I think we have them. Do any additional, the other judges need any additional information? Okay, I will double check that we've got everything set correctly as we continue or at the end before we present our scoring sheets. All right, I do believe that these are being streamed live for anybody to see. That being said, I do believe that there needs to be approval for any further recording or taping of the round. So just to verify that there's no additional or non-approved recording or taping, please speak up in chat or over Zoom if anybody does believe a video recording or taping is being present without permission. I will inform the teams that anybody that is on our presentation, the Colorado Bar Association may be taking photographs or screenshots, whatever they are doing in order to document the tournament, and that may be used in future Colorado Bar Association publications. Is there anybody viewing? So I do believe that the rules will still apply for the viewing of teams that you are not part of. Is there anybody viewing the session today who is not competing, connected with the teams, but not competing? And if so, I am going to ask you to stop viewing the proceedings unless you fall under one of those exceptions, and then to notify presiding judge and other members of the panel. Okay, a reminder that no teams or no recesses, will be allowed except for health emergency, and especially not between the end of examination and the beginning of closing arguments. If there is an emergency, please identify it in chat if possible. Obviously, if it needs to be identified a different way, please do that. Again, I'll remind the teams and coaches that any disputes arising out of this competition must be reported in accordance with the competition rules. Compliance with time requirements is a consideration in individual performance scoring. No coach or team member other than a timekeeper is seated in the jury box. And so however our jury box looks on Zoom. And I'm going to go ahead and at this time ask each team to introduce themselves to the panel.
Good
Starting
morning,
with the prosecution.
my apologies. Good
ahead.
morning, Your Honor, ladies and gentlemen of the jury, opposing counsel. My name is Marissa Ross. Today I will be delivering the opening statement, performing the direct examination of Kyle Kuzak, as well as the cross-examination of Avery Becker.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Desmond Decker, and I will be delivering the direct examination of Mrs. Alex Cifuentes. I will be delivering the cross-examination of Mrs. Taylor Perkins.
Good morning, Your Honor, the opposing counsel, members of the jury. My name is Colby Cruiser, and today I will be giving the direct examination of Detective Jordan Markowitz, the cross-examination of Professor Blake Van Owen, as well as delivering the closing argument. Permission at this time for our witnesses to introduce themselves.
Yes, thank you.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Tanner Moore, and today I'll be Alex Cifuentes.
Good morning, Your Honor, members of the jury. My name is Gavin Channel, and today I'm Detective Jordan Markowitz.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Justin Keith, and today I'm Cal Kuzak.
All right, thank you. And for the defense.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Cindy Nguyen. I will be performing the opening statement, the direct of Avery Becker, and the cross of Jordan Markowitz.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Maggie Holland, and I will be providing the direct examination of Taylor Perkins, the cross-examination of Alex Cifuentes, and I will be representing the Keystone attorney.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Raina Hilden, and I will be providing the direct examination of Professor Blake Van Owen, the cross-examination of Kyle Kuzak, as well as the closing argument. At this time, we request that our witnesses may introduce themselves.
Yes, granted.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Kaylee Langen, and I am Avery Becker.
Good morning, Your Honor, opposing counsel, members of the jury. I'm Lucy Ingram, and today I'll be Taylor Perkins.
Good morning, Your Honor, members of opposing counsel and the jury. My name is Sarah Mazer, and I am Blake Van Owen.
All right. At this time, I'm going to swear in our team members, the gallery, the scoring panelists, and the witnesses. At this time, I'm going to ask you to, team members, please raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? Thank you. Witnesses, if you could please raise your right hands. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements? Coaches, family members, and friends, please raise your right hands. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round?
We do.
All right, and finally, scoring panelists, if you can raise your right hands. And do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts and procedures and the rules of the mock trial competition? All right, thank you. At this time, I believe we are ready to begin presentations. Are there any pre-trial matters that any team would like to bring to my attention?
Yes, Your Honor. The defense asks that we would have permission for trial technicians to display exhibits on the screen for the purpose of entering them into evidence, or if they have already been entered into evidence for expediency's sake.
Yes, granted to both sides.
Your Honor, as exhibits are initially displayed on the screen, the prosecution would ask that it be recognized that it is just to display to the witness and opposing counsel, not to the jury until they have been published.
Yes, all exhibits will be deemed constructively displayed for parties only over the virtual Zoom and not admitted or published to the jury unless, of course, they've been admitted into evidence.
And then finally, in the event that someone is having technical difficulties, we ask permission for them to momentarily turn off their camera in order for the sound quality to improve.
Yes, my suggestion would be to notify the judge and scoring panelists so that we are in fact aware, notify the jury that we are aware of what is occurring.
Yes, Your Honor.
All right, thank you. Anything from the prosecution?
Yes, Your Honor. The only thing the prosecution asks is that in the event of any internet connection problems, in the event that we may be slowed down when pulling up and displaying evidence, that time may be paused briefly until that evidence is actually truly displayed for the witness to see.
You know what, I'm going to take that on a case-by-case basis. There is not a set rule regarding timeouts for technical issues. And so for the fairness of both parties, we can address any time issues related to technical issues as they arise.
Thank you, Your Honor. No further pre-trial matters.
All right, is the prosecution prepared to give an opening statement?
Yes, Your Honor. Half-hearted, hypocritical, and a whole-filled alibi. Ladies and gentlemen of the jury, today you are going to hear about the events of March 6, 2020. You are going to hear the story of Avery Becker, a promising mock trial student with a temper, and a rocky history with the deceased. You are going to hear about the murder of Mackenzie Brackman, a vengeful act of violence committed by Avery Becker as a desperate attempt at retribution. Now today, the prosecution carries the burden of proof. This means that we must prove beyond a reasonable doubt that on March 6th of 2020, Avery Becker unlawfully and feloniously attempted to commit second-degree burglary, and during the course and furtherance of that crime, the death of Mackenzie Brackman was caused by anyone. That on March 6th of 2020, Avery Becker unlawfully, feloniously, and knowingly broke into an entrance, entered, or remained unlawfully after a lawful or unlawful entrance into the dwelling of Mackenzie Brackman, with the intent to commit therein the crime of criminal mischief. Now, as we proceed through the case today, I ask that you focus on the facts, and you will believe beyond a reasonable doubt that Avery Becker committed the accused crimes. Focus on Avery Becker's whole-filled alibi and Blake Van Owen's half-hearted and hypocritical investigation, and it will be clear what truly happened on that fateful March day. Today you will first hear from Detective Jordan Markowitz, a homicide detective with the Denver Police Department. Detective Markowitz will walk you through his careful investigation and all that he saw firsthand at the crime scene. His years of experience and expertise will allow for him to reveal all of the holes in Avery Becker's suspicious alibi, especially with the incriminating phone records. His knowledge and passion for his work will also allow for him to show you all of the flaws in Blake Van Owen's work and all of the stuff that Blake Van Owen will try to bring up later on. Next, you will hear from Alex Cifuentes, Avery Becker's fellow mock trial member and peer. Alex Cifuentes will tell you about the disrespect that Avery Becker continuously showed towards not only her fellow peers, but especially Mackenzie Brackman, and all about the heated arguments and clashes between the two. Alex will also reveal a different side to Avery and show the rage that she could carry. Alex will tell you all about Avery's past encounters with Mackenzie Brackman and show that Avery had not only the intent, but also the motive to break into Brackman's house on March 6th, an event that eventually led to his death. Finally, you will hear from Kyle Cusack, a crime scene reconstruction investigator employed by the Colorado Bureau of Investigation. Cusack will tell you about all of the work that he did rebuilding the case, about how he looked through countless pieces of evidence and meticulously reviewed every detail, all to come to the conclusion that it was a burglary gone wrong. And Avery Becker fits the narrative. Now, today the defense is going to try to paint the picture of an innocent high schooler who just lost her mock trial coach. However, This same high schooler has a history of having an explosive temper and committing wrongful acts when things don't go her way. The defense is also going to try to say that the work that Detective Markowitz did was incomplete, and that the conclusions that Detective Markowitz and Kyle Cusack came to were incorrect. However, both Markowitz and Cusack will reveal a multitude of compelling evidence to prove their theory, and ultimately disprove Blake Van Owen's testimony. Half-hearted, hypocritical, and a whole-filled alibi. Today, I ask that you not get swept up in the story, but instead remain focused on the facts and the flaws in the defense's case. The countless holes in Avery Becker's suspicious alibi, the lies told by her friend to keep their story straight, and most importantly, the work of Blake Van Owen that was not only done without any heart or passion, but his words are also hypocritical to that of Detective Markowitz and Kyle Cusack. Your Honor, ladies and gentlemen of the jury, at the end of the case today, I ask that you come back with a verdict of guilty. Thank you.
Your Honor, I believe you are muted.
Thank you. Does the defense wish to give an opening statement?
Yes, Your Honor. May it please the court, Your Honor, members of the jury, opposing counsel. Good morning, my name is Cindy Nguyen, and along with my co-counsel, Raina Hilden and Maggie Holland, we are honored to be representing the defendant, Avery Becker. On March 6, 2020, the Colorado High School mock trial team's head coach, Mackenzie Brackman, was brutally murdered in his own home. My client, Avery Becker, stands here today accused of this horrific crime. But the truth of the matter is that she did not do it. The prosecution jumped to conclusions and fell short in investigating the killer of Mackenzie Brackman. Now, the law provides that all defendants are innocent until proven guilty. The burden of proof is borne by the prosecution, and they must prove my client's guilt beyond a reasonable doubt, which they will fail to do because of their flawed investigation. You're going to see screenshots of text messages between Avery Becker and Alex Cifuentes. However, beware of Alex Cifuentes' bias against my client. Alex was a member of the mock trial team who is not happy with Avery Becker's accomplishments, and today she will claim that my client sent these messages. You are going to see pictures of cell tower diagrams tracking my client's phone on the day of the murder. But the mobile device does not represent my client's whereabouts. You see, Avery Becker lost her phone the day before, and this phone could have been planted in the hands of the actual murderer in order to frame my client. A murderer who the prosecution failed to investigate as they chose to jump to conclusions instead. You're going to see videos of a masked intruder unlawfully entering Mackenzie Brackman's home. The prosecution will claim that my client has the same build as this intruder. But the prosecution jumped to conclusions and fell short by failing to look into another person with the same build and body shape, someone with a greater motive to kill Brackman, and that person is Blair Rollins. You see, a few months before the murder, Brackman failed to represent a man named Jonathan Rollins in a murder charge, and Rollins was convicted and sentenced to life in prison. From this imprisonment, Jonathan Rollins' child lost a father. This child, Blair Rollins, could be an equal suspect in this case. But once again, the prosecution jumped to conclusions and fell short when they neglected to look into any suspects other than my client. Listen to the prosecution explain how they investigated the whereabouts of Blair Rollins on March 6th. Without that evidence, members of the jury, you have the basis for reasonable doubt. Now, the defense will call 3 witnesses, Avery Becker, Taylor Perkins, and Blake Van Owen. The defendant, Avery Becker, was a naturally gifted, award-winning attorney on the mock trial team. You will hear that Miss Becker and Mr. Brackman did not have a great relationship. However, while Miss Becker and Mr. Brackman did not always see each other eye to eye, they were on the same team, the mock trial team.
Beth, have some kind of
Second witness, Taylor Perkins, will testify that my client.
Somebody who tested positive, so she got a test and doesn't know and isn't working right now.
Oh.
Just.
And Miss, there's a Vicky channel that is online. Can you please mute your line? Thank you. Please continue.
I'll just start on my witnesses again. The defense will call 3 witnesses: Avery Becker, Taylor Perkins, and Blake Van Owen. The defendant, Avery Becker, was a naturally gifted, award-winning attorney on the mock trial team. You will hear that Ms. Becker and Mr. Brackman did not have a great relationship. However, while Ms. Becker and Mr. Brackman did not always see each other eye to eye, they were on the same team, the mock trial team. Our second witness, Taylor Perkins, will testify that my client was with her the entire day of Mr. Brackman's death. The two went to the mall and the fry shack to retrace their steps and search for the missing phone. Taylor Perkins will testify under oath that Avery Becker has an ironclad alibi for the date and the time of the crime. Our third witness, Blake Van Owen, will dispute the prosecution's claims of how the murder was carried out, and she will question the validity of every piece of evidence that the prosecution collected during their investigation. Not only was their investigation sloppy, but they lost pieces of evidence they collected as well. Like I said, the prosecution is not interested in the truth. They're simply jumping to conclusions to get a quick conviction. At the end of this trial, my co-counsel, Raina Hilden, will recount the instances in which the prosecution jumped to conclusions and fell short in procuring the evidence presented to you today. Again, in order for my client to be deemed guilty, the prosecution must meet the burden of proof, which is to prove Avery Becker's guilt beyond a reasonable doubt, which they will fail to do. At the end of this trial, we will ask you to rule in favor of the defense and acquit Avery Becker of her coach's murder. Thank you.
Thank you. Does the prosecution wish to call their first witness?
Yes, Your Honor. The prosecution now calls Mrs. Alex Cifuentes to the stand. Mrs. Cifuentes, could you please state your full name and spell your last name for the record?
Yes, Alex Cifuentes, Sifuentes.
Thank you. Could you please tell me a little bit about who you are?
Yeah, I'm a member of the CHS mock trial team alongside Avery Becker and Taylor Perkins.
Now, what was your relationship to Coach Mackenzie Brackman?
Mr. Brackman was an amazing coach whom I looked up to and respected greatly.
And what was your relationship to the defendant?
I consider Avery to be one of my best friends. She was actually the one who convinced me to join mock trial in the first place.
Now, based on your experiences through mock trial, what can you tell us about your experience with Avery?
Avery had a little bit of a lackadaisical attitude. She would never really show up prepared, but she always seemed to pull through in the end.
And based on your observations, what were the interactions like between Avery Becker and Coach Brackman?
Avery and Mr. Brackman seemed to have a really tense relationship. Mr. Brackman was always telling Avery to come better prepared, but Avery never seemed to listen.
And what was the impact of Avery's behavior on the rest of the team?
Since Avery was never really prepared for competitions, she was kind of a wild card, and we never knew if she'd be prepared or be able to pull it off or not.
What did you think of Avery's behavior and lack of respect for the team?
Personally, it kind of hurt a bit since I always came super prepared and Avery didn't, so it hurt when I came really prepared.
Thank you. Did Coach Brackman ever say anything to Mrs. Becker about her lackadaisical attitude?
Yeah, Mr. Brackman was always telling Avery to be better, but she never really listened anyways.
Did Coach Brackman and Mrs. Becker's relationship ever grow to a breaking point?
Yes, one day when Avery showed up late to practice for the umpteenth time, as a result, Mr. Brackman demoted her to the B team.
Did anything else happen after Coach Brackman let Mrs. Becker back on the team?
Yeah, somehow Avery convinced Taylor Perkins to quit mock trial so that she'd be put back on.
Objection, Your Honor. Speculation.
Response?
Your Honor, the client's not speculating. It is known that Taylor Perkins did convince, or Avery did convince Taylor Perkins to quit the team for her.
I'm going to sustain it, but I'm going to let you just lay a bit more foundation as to where she's receiving that information or how she has that information.
Okay. Thank you. Mrs. Cifuentes, could you please tell us how you would know whether or not Taylor Perkins was convinced to leave the team?
Yeah, Taylor just quit the mock trial team so that by default, Avery was put back on to A team.
And were you on this team?
Yes, I was.
What was Avery's reaction?
Avery was actually won the Best Attorney Award at the regional competition when she was reinstated on A team.
And did anything else happen after Coach Brackman let Avery back on the team?
Yeah, after Avery won these awards, Mr. Brackman talked to Avery after and said that in the real world, this would be considered a malpractice since Avery came very unprepared.
And what was Avery's reaction to being told this?
Objection, Your Honor. Rules for speculation. Ms. Cifuentes was not at this practice when this happened.
Response?
Your Honor, Mrs. Cifuentes knows what Avery did as she was on the team. She may not have been at that practice, but she was on the team and knows what happened.
I'll overrule the objection if she can lay foundation that she's aware of what occurred.
Mrs. Cifuentes, what did Avery do after she was told this?
Avery grabs what she claims was an expo marker and vandalized Mr. Brackman's Porsche.
Did Coach Brackman punish Avery for vandalizing his Porsche?
Yes, at this point, Mr. Brackman kicked Avery off the mock trial team once and for all.
Did Avery being kicked off the mock trial team benefit you personally?
I mean, yes, it would have, but we couldn't have gone to state without Avery anyway, so what does it matter?
Did you ever try to help Mrs. Becker to reconcile for her actions?
I did. I tried talking to Mr. Brackman, but it was no use.
Thank you. Your Honor, permission to approach the witness with what has previously been marked as Exhibit 14.
You can approach.
Okay. Sorry, I'm having trouble pulling this up. Mrs. Cifuentes, could you please describe to us what is in this exhibit?
Yes, these are text messages between Avery Becker and I where she implicates vandalizing or messing up Mr. Brackman's house as well.
Thank you. Did you take these screenshots?
Yes, I did.
And are these screenshots a true and accurate copy of the conversation that you and Avery had?
Absolutely.
Your Honor, the prosecution now moves to admit Exhibit 14 into evidence as a record of the text communication between Alex Cifuentes and Avery Becker.
Any objection?
No objections, Your Honor.
Okay. And that'll be admitted and published for the jury.
Thank you, Your Honor. Now, Mrs. Fuentes, what happened as a result of Avery Becker not being reinstated on the team?
She texted me, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
And what is it that Avery said that she was going to do to Coach Brackman's house?
She said she was going to wait until he was at work and then break in and trash his house.
Thank you. Did you ever talk to anyone about the murder?
Yes, I talked to a detective.
And what did the detective ask of you?
The detective asked me just to say anything I knew about Avery Becker and about the screenshots and just other things I knew about her.
Did you show the detective these screenshots?
Yes, I did.
And did anyone else try to contact you after the murder of your coach?
Yeah, there was an investigator for the defense that tried to come talk to me, but I wasn't interested in talking with them.
And did you ever use Avery's phone to text anyone?
Absolutely not.
Would you ever do anything that would bring harm to your coach?
No, I loved Mr. Brackman.
Thank you. Your Honor, no further questions at this time.
Thank you. Cross-examination?
Yes, Your Honor. All right, let's start by talking about the defendant. You know Avery Becker from your high school mock trial team, correct?
Yes, I do.
And you were teammates for 4 years?
We were.
You were a hardworking member in mock trial, correct?
I put a lot of time into mock trial.
And you took it very seriously?
I did, yeah.
And you didn't think Avery worked very hard in mock trial, do you?
No, Avery just kind of tranced in, but she was a really big contributor to the team.
Avery was rarely prepared though, yes?
Yes, that's true.
Yet Avery frequently received awards, correct?
Yeah, she did. She was a really good part of our team, and she got us lots of awards.
But with this so-called lackadaisical attitude, it bothered you that Avery received all of these awards, yes?
I mean, yeah, but it benefited our team as a whole, even though it did hurt me a bit.
It bothered Mr. Brackman as well, correct?
Objection. This question calls for the witness to speculation.
Response?
Your Honor, I believe is the mock trial, the relationship between coach and a mock trial teammate that Ms. Fuentes would have enough knowledge to be able to testify in the feelings of Mr. Brackman, who cannot come to court today.
I'm going to go ahead and sustain the objection. I will allow you to ask her anything she observed about him that may have led to any conclusions about his feelings, if that makes sense.
Yes, Your Honor. This lackadaisical attitude boiled to the point that Avery was kicked off of the team, yes?
Yes, it did.
And you were glad Avery was kicked off of the team, weren't you?
I mean, I would have gotten a bigger role, but at the same time, we couldn't have gone to state without Avery, so what does it even matter?
But it did open up an opportunity for you, correct?
Yeah, I guess I would have gotten a bigger role.
Avery texted you asking to speak to the coach on her behalf, yes?
Yeah, she did.
But you don't have these texts.
I sent screenshots to the detective, and the detective told me the screenshots were just as good as if I had the phone in front of me.
But you have not produced your phone at any point in time, have you?
No, that phone's traded in now.
You never showed these texts to law enforcement?
No, I just sent them the screenshots like they asked.
Objection, Your Honor. This is to the relevance of whether or not Mrs. Cifuentes had indeed helped Avery to get back on the team. That's not relevant at all.
Response?
I believe this this exhibit has been entered into evidence, these text messages, so it is incredibly relevant to the trial.
Your Honor, permission to respond.
You may.
The texts that opposing counsel is referring to are not admitted to evidence. These are completely separate texts about whether Avery tried to help get back on the team, and she herself has said that these were not presented.
I'm going to overrule the objection. I think it goes to bias and motive, and that has been touched on. So I'll overrule the objection.
Picking up where we left off, you, as you said, you traded this in a few months ago.
Yes, I did.
Knowing that your former classmate was facing trial for first-degree murder.
Yeah, I did. My battery just wouldn't hold, and it was time for me to get a new phone anyways. It was completely irrelevant to the issue at hand.
My apologies for interrupting, but you still traded this phone in knowing your previous phone may have contained exculpatory evidence.
I had already given the screenshots to the detective. I thought my part was done at this point.
Speaking of phones, Avery let you play a game on their phone at the Fry Shack the night before the murder, yes?
Objection, Your Honor. We're assuming facts, not in evidence.
Response?
I believe this is in the witness's affidavit.
Okay, I'll overrule. She can ask that question.
Would you like me to repeat the question?
Yes, please.
Speaking of phones, Avery let you play a game on their phone at the Fry Shack, correct?
Yes.
The same night that Avery lost their phone?
Yeah, that is true.
And you and Avery have texted back and forth in the past, yes?
We have.
So Avery was a saved contact in this phone?
Avery was a saved contact in my phone, yes.
If you will allow Exhibit 14, my trial technician to present on their screen Exhibit 14, which I believe has already been admitted to evidence.
Granted.
If you will read along with me on the first line of that text. Hey, Alex, it's Avery. If Avery was a saved contact in this phone, they wouldn't have needed to identify themselves, would they?
I mean, that's not an unusual thing. I can't go towards saying what Avery's text etiquette is.
It wasn't necessary though. It might have, since they were already a saved contact, yes?
Objection, Your Honor. The opposing counsel is calling for the witness to speculate onto whether or not it would be normal for Avery to say, hey, Alex, it's Avery.
Response?
This doesn't require any speculation because it's what Ms. Cifuentes herself believes to be odd.
I'll overrule the objection.
So this was odd and unnecessary, that if Avery was a saved contact in the phone, they wouldn't have needed to identify themselves, correct?
I mean, not necessarily. I can't go to say as to why Avery thought the need to recognize herself in the text message.
No further questions, Your Honor.
Okay, any redirect?
Yes, Your Honor. Mrs. Cifuentes, based on your observations, did Avery's lackadaisical attitude cause hostility between Avery and Coach Brackman?
Yes, it did.
And would your phone have been helpful at all with its unreliable battery?
No, it wouldn't have.
Did you give Avery her phone back when you played a game on it at Fry Shack?
Yes, of course.
Thank you. No further questions, Your Honor.
All right, and based only on those, is there any recross?
No, Your Honor.
All right, may this witness be excused. Okay, this witness may be excused. Prosecution have a second witness?
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand. Detective Markowitz, could you please state your first and last name and spell your last name for the record?
Of course. My name's Detective Jordan Markowitz. That's spelled Markowitz.
What is your profession?
I have the privilege to work as a homicide detective with the Denver Police Department.
And how long have you been with the Denver Police Department?
I started there about 13 years ago, and I've been a detective for the last 7 years.
What do you do as a detective?
I get to handle all kinds of investigations. However, as a homicide detective, I primarily handle cases like this in which we have a deceased victim. And then I furthered the investigation through conducting interviews, pursuing suspects, and spending lots of time at crime scenes.
What other specialized training do you possess?
My primary specialty is with cell phones. I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement.
What did this course cover?
I learned about the types of cell tower data and records that can be obtained, how to use forensic software to download information from a cell phone, how to acquire and interpret cellular records, and how to obtain and interpret cell tower data.
Do you use this training in your day-to-day work?
I use this training constantly, primarily because it's very interesting, and it also allows me to download the contents of hundreds of cell phones. I've actually obtained and interpreted cell tower data in over 50 cases.
Your Honor, the prosecution moved to have Detective Jordan Markowitz designated as an expert in the field of crime scene investigation, as well as cell phone technology and forensic data recovery pursuant to Rule 702.
Any objection?
Yes, Your Honor. May I please perform a brief voir dire?
You may.
Detective Markowitz, you received your certification in cell phone technology and forensic data recovery in 3 days training?
Is that a question?
Yes.
Yes, I received my certification after a 3-day course, and since then I've used that knowledge and training, I'd say every day of my career.
Your Honor, at this time, I have no objections to Detective Markowitz being admitted as an expert in criminal investigation. However, I object to the specialization in the field of cell phone technology and forensic data recovery, as I believe that only 3 days of training is not sufficient enough to prove that the witness is specialized in this field.
Any response?
Yes, Your Honor. Based on the fact whether this course was 3 days or 3 years long, I believe it is evident that my witness has not only the experience and education, but also has provided evidence of this education in his day-to-day work for the last many years in this field, and therefore shall be designated as an expert in that line of work as well.
Great, thank you. I will overrule the objection and I will qualify him as an expert in crime scene investigation, cell phone and data recovery.
Thank you. Detective Markowitz, were you assigned this case?
Yes, I was assigned to investigate the death of Mackenzie Brackman in March of 2020.
What was the call that came into dispatch?
On Friday, March 6th, a passing motorist reported seeing a person possibly unconscious on the porch of a residence at 444 South Flower Street. And then paramedics responded and called for officers when the victim was found deceased just inside the front door of the residence.
When did uniformed officers arrive on scene?
Uniformed officers secured the scene, and then I arrived at 1420 hours or 2:20 p.m.
What did you initially notice upon arriving at the crime scene?
First, that the front door was wide open. The victim was face down on the floor just inside the residence in a pool of blood. And there was a large knife visible on the floor just past the victim's body. The victim's shirt was blood-soaked around the left posterior acromial region, or the back of the left shoulder, and it was obvious that the victim had been stabbed.
You're on permission to show the witness copies of what have been previously marked as Exhibits 1 and 5.
You may.
Let the record reflect. I'm going to share my screen. Now, Detective George Markowitz, I'm going to show you both Exhibits 1 and 5. Do you recognize these documents?
Yes.
What are they?
These are some of the photos of the crime scene taken while I was there.
Now, are these photos fair and accurate representations of the victim as well as the victim's home?
Yes.
Your Honor, the prosecution moves to have Exhibits 1 and 5 admitted into evidence.
Any objection?
No objections, Your Honor.
All right, Exhibit 1 and Exhibit 5 are admitted and may be published.
Thank you, Your Honor. Now, Detective Markowitz, could you please explain to the jury first what you see in Exhibit 1?
Of course. Exhibit 1 shows a photo of the victim lying down in the doorframe of the residence, as I was saying, with the pool of blood. And in the top right of the photo, you can see the Ring video camera that we used later on in our investigation. And then in Exhibit 5 is a photo of the murder weapon, the knife used in this murder.
Now, I'd like to go back to that Ring camera that you noticed. Did you notice any other cameras around the outside of the home?
Yes, there were 3 total cameras located at the front door, the side gate, and the back door.
Did you go inside the residence?
Yes, I entered through the back door.
What did you notice upon entering the back door?
The home was in slight disarray. There was a partially open kitchen drawer containing several knives, as well as a knife block in the corner with an empty slot, telling me that a knife had recently been taken from its area.
Where did you investigate next in the home?
The dining area next to the kitchen.
And what did you see there?
There was a chair knocked over, as well as a broken plate on the floor, indicating a struggle.
Did you find any blood in this area?
Yes, there were cast off blood splatters in the dining room and near the front door.
What did you do next?
I saw the open door and the knife, and I let the forensics team come in.
Did it appear as if anything was taken from the Brackman home?
No, in fact, expensive items such as a laptop and several flat screen televisions had been left undisturbed.
Based on the on-scene evidence, what did it appear had happened?
It seemed obvious to me that the victim had caught someone breaking into their home and had then confronted the intruder with a large knife from the kitchen, but the defendant got control of the knife and then stabbed the victim.
Did you obtain the victim's phone?
I did.
And what did you do with that phone?
I downloaded information from Mr. Brackman's phone. I obtained account data and passwords for his Ring account.
Were you able to obtain videos from this Ring account?
Yes.
Your Honor, permission to show the witness a copy of what's been previously marked as Exhibit 10.
You may.
Let the record reflect I'm now going to share my screen. Now, Detective Markowitz, do you recognize Exhibit 10?
Yes, this is one of the video links of the Ring video cameras.
Is this the same video link you obtained from the victim's phone?
Yes.
Are the contents of this video link a fair and accurate representation of the victim's home?
Yes.
Are they a fair and accurate representation of the crime scene that you investigated?
Yes, they are.
How do you know these are the correct videos?
When I was investigating, I could see in the video that the house contained is in fact the Brackman residence.
Your Honor, the prosecution moves to admit Exhibit 10 into evidence.
Any objection?
No objections, Your Honor.
Exhibit 10 is admitted and may be published to the jury.
Detective Markowitz, I'm going to play Exhibit 10 for you, and I'd like you to explain to the jury what you see.
In this video, you can see that the suspect likely arrived to burglarize the home, however, alerted the homeowner when they failed to get in the front door. And then in the other videos, you can see they subsequently came in through the back door, then had a struggle with the victim who had grabbed a knife from their home, then killed Mr. Brackman and fled from this scene.
Thank you. Now, does the individual in the video match the victim's body type? Or I apologize.
Yes.
Body type?
Yes, Mrs. Becker's body frame does appear to fit the frame of the individual in the video.
What else did you find on the victim's cell phone?
I found many emails and texts from something called mock trial.
Did you investigate the victim's mock trial activity?
I did. I was following as many leads as possible, so I reached out to the school to obtain the contacts of the student members.
Did you speak with any students?
Yes, I spoke with a student named Alex Fuentes about another student who had reached out to them about a plan to trash Mr. Brackman's home.
Did you and Mr. Fuentes have any further conversations?
Yes, I had Alex and her parents come to the station to conduct an interview.
Who was the other student that Alex Fuentes mentioned?
Mrs. Avery Becker.
Did it appear that this Avery Becker had any kind of connection to Mr. Brackman?
Yes, in fact, Mrs. Becker had recently been kicked off the team for vandalizing the coach's car and had been pleading with Alex to get her back on the team.
Did you investigate Ms. Becker?
Yes, I obtained a warrant to search Mrs. Becker's cell phone.
Did this warrant result in anything?
No, when I made arrangements to get the phone, the attorney said the phone had been lost on March 5th of 2020.
Were you able to obtain any cell tower records from the victim or from the suspect?
Yes, I got these with a court order for information from March 6th, and they're called call detail records or CDRs.
Can you briefly explain these CDRs?
Of course. Cell tower information is recorded when a communication is made, like sending a text or receiving a call.
Now, what do the CDRs in this case reflect?
They can tell us the date and time of communication, as well as the specific towers with which the phone was communicating, and even the specific antenna of that tower.
Now, what do the CDRs in this case reflect?
They reflected that another phone was sending several texts and placing several calls to Mrs. Becker's phone leading up to when the victim was stabbed.
Who did the other phone belong to?
Taylor Perkins, another student at Colorado High School.
Was it surprising that these calls or texts weren't answered?
No, considering what Mrs. Becker was doing at the time on the way to a murder scene, I wouldn't be surprised if she was a little busy to be answering the phone.
When did the phone last connect to a cell tower?
Activity ceased around 13:20 hours or 1:20 p.m.
And what did this make you suspect?
The phone was turned off after the murder and disposed of.
Did you put together a representation of the phone data you collected?
Yes, I put together a diagram as seen in Exhibit 16.
Your Honor, let the record reflect. I'm going to now show the witness a copy of Exhibit 16.
You may.
Now, Detective Markowitz, do you recognize Exhibit 16?
Yes.
Do you often compile diagrams like these in the course of work?
Yes, it helps me to summarize all of the call detail records that I compile into an easier to understand document for juries.
Does this diagram fairly and accurately reflect the information that you collected?
Yes, it does.
Prosecution moves to admit Exhibit 16 in evidence.
Any objection?
No objections, Your Honor.
All right, Exhibit 16 is admitted and you can publish for the jury.
Thank you, Your Honor. Now, Detective Markowitz, could you walk us through what the diagrams help us?
Yes, you can see that Mrs. Becker received a text from Taylor Perkins at about 12:47 p.m. with communication at tower intent at 12:27:3. Another text came at 12:55 at intent at 11:91:1. And then next was an incoming call at 13:05 and at 13:06, then a text at 13:17, all unanswered at intent at 11:97:1, the closest tower to Mr. Brackman's home.
Based on all of this, what does the CDR indicate in this case?
It indicates that Mrs. Becker was home around 12:45, left and drove towards the Brackman home along Rock Creek Parkway, then was at the Brackman home from 1:05 to 1:17 p.m.
Based on all the evidence that you've collected in this case, what does your expertise tell you?
It's clear that Avery Becker went to the Brackman home on March 6th of 2020 with the intent to break in and vandalize the home in retaliation for being kicked off the team. But Brackman was actually home and alerted by the ring cameras, and Brackman armed himself with a knife before confronting the intruder, who wound up struggling and taking the knife, then killing the victim with a stab to the left shoulder.
Do you believe that Avery Becker had set out to kill Mackenzie Brackman?
No, but Avery Becker still killed Mr. Brackman in the midst of a burglary.
Thank you. No further questions at this time, Your Honor.
Thank you. Does the defense wish to cross-examine?
Yes, Your Honor. May I proceed?
You may.
Detective Markowitz, you took pictures of blood on the floor and walls of Mr. Brackman's home, correct?
It wasn't me personally, it was the crime scene photographers, but yes, there were photos, many photos taken at the crime scene.
But the digital files in the camera you used became corrupted and could no longer be recovered?
As you can see in exhibits 1 through however many, the majority of the photos were still there. However, a couple of the photos were lost. Luckily, the investigation was still able to continue even without this little bit of a hiccup.
So the prosecution jumped to this conclusion today, even when they fell short in collecting evidence that could or could not have exonerated the defendant?
I don't think we jumped to any conclusions, and those photos were simply photos of the cast-off blood splatters, which is the blood that comes when the knife comes out of the wound. So by no means could that have exonerated the suspect. I would say we went step by step and reached our conclusion in a thorough manner.
However, you cannot be 100% certain that this evidence could or could not have exonerated the defendant.
I can be sure because I know what it contained, and I know that that evidence, it was less important than other evidence that was included.
At this time, I would like to direct your attention to Exhibit 10, the ring video, which has previously been admitted to evidence. Let the record reflect that the trial technician is screen sharing what has been previously marked as Exhibit 10. If the trial technician could please play that video and stop at approximately 4 seconds. Okay. And Detective Markowitz, you claim that this is Avery Becker, correct?
Yes.
And if you take a closer look at this exhibit, you jump to conclusions even though you don't know the race of the person in this video.
Clearly, you can't see the race. However, there was evidence later with the call detail records, which I think I thoroughly explained earlier, that placed Avery Becker at the scene of the crime.
Detective Markowitz, if you could please just answer these next questions with a simple yes or no. You don't know the age of this intruder.
No.
You don't know their gender.
No, I'd assume it's female because Avery Becker is a female.
However, you don't know with 100% certainty.
I would say I'm very certain.
And you don't have any evidence tying that mask to my client?
No, but again, like I said, the call detail records placed Avery Becker at the scene of the crime, and then these videos again placed the suspect at the scene of the crime.
Detective Markowitz, you don't have any evidence tying that mask to my client or those clothes.
No.
Now, let the record reflect that the trial technician has stopped screen sharing the exhibit. Detective Markowitz, directing your attention to the call detail records. In looking at these records, you noticed incoming calls and texts that weren't responded to?
Yes.
And you jumped to the conclusion that they weren't answered because of what Avery Becker was doing at that time, but wouldn't they be unanswered if the phone were lost?
Well, based on the position of the phone calls, as you can see in Exhibit 16, I traced a path that was likely Miss Becker's route to Mr. Brackman's home. And based on the position of the incoming calls and texts, I could tell that she was moving and she was on her way to the victim's home.
However, Detective Markowitz, there's no way to determine who is in possession of the phone through the call detail records, correct?
No, but on a weekday afternoon, going from one residence to another, it's highly unlikely that it would be anyone else except Avery Becker.
Is it possible that the incoming calls to the phone were made in attempts to locate the phone?
Yes, I assume Taylor Perkins was confused where her friend was. And she later found out that she was on the way to commit a crime.
And is it possible for a cell phone to connect to a tower that is further away?
It is, but as you can see in Exhibit 16, if you wouldn't mind sharing it, or you don't have to, but there's 3 antennas in this scenario here. One facing this way, one facing this way, and one facing here. Based on the position of them and the antennas, we know that Avery Becker was within that area.
However, if you could answer my question, Detective Markowitz, it is possible for a phone to connect to a tower that is further away.
Yes, but like I said, Avery Becker was within those 3 antennas.
Now, directing your attention to one of your witnesses, you contacted students on Brackman's mock trial team with your biggest lead coming from Alex Cifuentes.
Yes, I tried to conduct an interview with everyone on the team.
And this lead was evidence of text messages between Cifuentes and who she claims is Avery Becker?
Yes, she was discussing them, and then I later asked if she could share those texts with me.
Detective, did you witness these texts being sent from Avery to Alex?
No, but I saw the conversation on the text messages.
Sorry for interrupting you. Detective, you are 100% certain that these texts were sent from Avery's number?
I would say I'm very certain, yes.
Are you 100% certain?
Would you like me to explain why I'm so certain?
No, I would not.
Okay.
Yet you quickly jumped to accept these screenshots without any validation or further examination of its validity.
These text screenshots weren't evidence pointing to Avery Becker as a criminal. They simply led me to pursue that investigation, which then led me to evidence painting Avery Becker as a criminal.
Detective, you acknowledge that there are ways to forge a text conversation, perhaps through a text messaging app?
Yes, I'm aware, and like I said, these texts were one reason why I furthered my investigation into Avery Becker, as a motive was clearly present. They weren't the evidence themselves, but they led me to find the evidence.
And it is relatively easy to change the name of a contact, correct?
Yes, but like I just said, that's pretty unimportant here.
However, you cannot be certain if any tampering occurred with the evidence, as these are screenshots and not the actual phone.
Your Honor,
again,
the question's been asked and answered.
Response?
Your Honor, I do not believe I have asked if they have been tampered with. I have asked questions regarding changing the contact or text messaging, but I have not asked if the witness is 100% certain if any tampering occurred.
Overruled.
Again, Detective Markowitz, you cannot be certain if any tampering occurred with the evidence.
With these texts in particular, is that what you're asking?
Yes.
No, I cannot be sure, but again, it doesn't really matter because these texts were why I furthered my investigation into Avery Becker. They were not the evidence themselves, but they helped me find the evidence through my furthered investigation.
And Detective Markowitz, you asked for screenshots of the text conversations instead of investigating the direct source.
Yes.
No further questions, Your Honor.
Right. Any redirect?
Yes, Your Honor. Detective Markowitz, did corrupted photos of blood spatter impact your case whatsoever?
Not at all. We had plenty of evidence at hand, and that little hiccup did not pose any problems for us.
Based on what you could see in multiple Ring camera videos, did the body size of the individual in those videos match that of Avery Becker?
Yes, very clearly.
Based on your investigation, did Avery have a clear motive to commit this crime?
Yes, the text conversation showed me that motive, and then I pursued my investigation.
Do you believe you jumped to conclusions in this case?
Not at all. Working at the Denver Police Department, we are very thorough in every investigation.
No further questions, Your Honor.
All right. Based on those questions, any recross?
No, Your Honor.
Thank you. This witness may be excused. Does the prosecution have any further witnesses?
Yes, Your Honor. The prosecution calls Kyle Cusack to the stand. Hi, could you please state your name and spell your last name for the record?
Hi there, my name is Kyle Cusack. Cusack is K-U-Z-A-K.
What is your profession?
I'm a Colorado Bureau of Investigation certified crime scene reconstruction investigator, also known as a CSR.
And how long have you worked as a CSR?
I've had about 19 years of experience at this point in my life.
Can you please give a brief description of what that title entails?
Sure thing. So basically, I investigate complex crime scenes. Guided by standard CSR principles and the scientific method, I identify, analyze, and interrelate different event segments in order to construct a chronology of the crime.
And what kinds of crime scenes do you have experience investigating?
A multitude. I've done home invasions, burglaries, homicide, fatal accidents. In other words, I get around.
So a few questions ago, you mentioned your investigative work as a CSR is guided by standard principles. What are some of these principles that you follow in your everyday work?
Well, I tend to follow a 5-step process. One is the recognition and documentation of a crime scene. The second is the collection of evidence. The third is the evaluation of that evidence. The fourth is the formulation of hypotheses based on that evidence. And finally, number 5 is formulating a final chronology of the crime.
What is the main purpose of CSR work?
As I said before, basically, we are supposed to create a timeline of events. We analyze the how the crime occurred.
Do you follow any methodologies when conducting your analysis?
I do. In particular, I follow Tom Bevel and Ross Gardner's 7-step methodology for event analysis.
Your Honor, at this time, I move to admit Kyle Cusack as an expert in crime scene reconstruction and investigation pursuant to Rule 702.
Any objection?
No objection or voir dire, Your Honor.
All right. He's admitted as an expert in the named areas.
Thank you. Can you briefly walk the jury through how you analyzed and reconstructed the murder of Mackenzie Brackman?
Sure. So with every case I'm involved in, I immediately assume that it's going to trial. As a result, I tend to create evidence tracking spreadsheets in order to make it as clear and concise to an outside observer as possible. In this particular instance, I formulated a witness tracking spreadsheet and a physical evidence tracking spreadsheet so I can interrelate relationships between those involved, as well as identify crime scene numbers to department investigation IDs.
So how do you use these charts and spreadsheets that you mentioned to help you with your investigation?
Well, through the interrelation of event segments, we're able to determine a timeline of events per se, basically ruling out alternative possibilities and strengthening the case for others.
What are the final steps in the conduction of your analysis?
In the end, I just peer review and eliminate contradictions before preparing my final report.
What evidence did you review as you rebuilt this case?
In particular, besides the body and the surrounding gruesome evidence around it, we noted the scuff marks at the kitchen floor, the broken table at the base of the kitchen, the broken plate at the base of the kitchen table, a knife block in the kitchen with a missing large chef knife, and a knife drawer that was left ajar.
Are there any further steps in your analysis?
Sorry, can you say that again? I didn't quite hear that.
Are there any further steps in your analysis and your investigation?
After the peer review and formulating the final hypothesis?
Yes.
No, I don't believe so.
So based on your investigation, what was the sequence of events on the afternoon of March 6, 2020?
Well, based on the Ring security camera videos that were talked about earlier, we can conclude that the perpetrator went to Brackman's front door before immediately proceeding to the backside of the house. Brackman, of course, was alerted to the culprit's presence, so the victim found a knife to defend himself. In the end, the perpetrator ended up entering the residence through the back, and the two engaged in a scuffle, during which the scuffle moved to the front of the residence, indicated by a broken dish at the bottom of the table. And in this process, the victim was disarmed, and the perpetrator obtained the knife and thus stabbed it into the victim's scapula, also known as a shoulder blade. Soon afterward, the perpetrator left, and the victim removed the knife, thereby dying from exsanguination, which is basically a fancy SAT word for blood loss.
What conclusions did you come to based on the analysis of the physical evidence?
In short, this was a typical burglary gone wrong. Based on all the scientific method that was employed, we were able to determine that this is the sequence of events.
And do you feel confident in your conclusion?
I do.
No further questions at this time, Your Honor.
Cross-examination?
Yes, Your Honor. And may I please have a brief time check before I begin?
You may.
Awesome. Thank you. So good morning, Mr. Van Owen. So if we could please just get right into it, let the record reflect that the trial technician is displaying what has been previously marked as Exhibit 8 on the screen. Thank you. Now, you saw this knife, or do you recognize this exhibit, Mr. Cusack?
Yes, ma'am.
You had seen this at the crime scene?
That's correct.
Thank you. And this image is accurate to what you had observed, correct?
That is right. As you can see, it's missing a large chef's knife, like the one found in Mr. Brackman's scapula.
Thank you. At this time, the defense moves to enter Exhibit 8 into evidence.
Any objection?
No objection, Your Honor.
Exhibit 8 is admitted and may be published.
Thank you. Now, Mr. Cusack, this is a J.A. Heckles knife set, correct?
That's correct, yes.
But the knife found in Mr. Brackman's shoulder was a Chicago cutlery knife, correct?
Yes, ma'am.
And yet you concluded that these came from the same knife block?
Yes, due to the fact that usage of knives often end up in them broken or damaged, it's quite common for them to be replaced with a different brand.
Thank you. Moving on, could the trial technician please, or could the record reflect that the trial technician is displaying Exhibit 18? Thank you. And do you recognize this exhibit?
Yes, those appear to be the scuff marks at the back door of the residence on the base of the kitchen floor.
And does this image accurately reflect what you observed at the crime scene?
It does, yes.
Thank you. At this time, the defense moves to enter Exhibit 18 into evidence.
Any objection?
No objection, Your Honor.
At this time, Exhibit 18 is admitted and may be published.
Thank you. Now, Mr. Cusack, do you have any way of knowing the time when these scuff marks appeared?
No, but we can theorize that it occurred during the scuffle that began at the back door of the residence.
But there are no before and after picture comparisons of Mr. Brackman's floor?
No, given that the crime scene was secured after the crime occurred.
Thank you. But essentially, seeing as these are right by the door, they could have just as easily come from regular movement in and out of the house, correct?
Yeah, such as the culprit entering the house itself.
But you don't have any concrete evidence that that was the case, correct?
Nor any other evidence for the alternative, no.
Thank you. And finally, if the record could reflect that the trial technician is displaying Exhibit 11 on the screen. Or excuse me, I misread, Exhibit 17. Mr. Cusack, this is your expert report, correct?
Yes, it appears to be my witness tracking spreadsheet.
Thank you. And this is a document created by yourself?
Yes, ma'am.
And is this accurate to your work?
It's a little blurry, but I believe so, yes.
Thank you. At this time, the defense moves to enter Exhibit 17 into evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 17 is admitted and you may publish it for the jury.
Thank you. Now, if I may direct your attention to the top box on the right, and if the record may reflect that the trial technician will annotate part of the first line through the third line. I will read that if you could please follow along with me, Mr. Cusack. Regarding Taylor Perkins, provided statement, whereabouts with S1 on day preceding and day of homicide. I read that correctly, did I not?
Yes, ma'am. Yes.
Thank you. So your own report acknowledges that Taylor Perkins provided an alibi for Avery Becker on the day of the crime?
Yes, ma'am.
Thank you. And a next annotation, let the record reflect that the trial technician is highlighting the final line. And if you may read along with me once again, unlocated party, Blair Rollins. And once again, I read that correctly, didn't I?
You did, yes.
Thank you. So your own report, just for the sake of clarity of the jury, acknowledges that nobody could locate Blair Rollins after the crime?
Yes, but may I ask?
Honor.
Oh,
I
excuse
don't
me.
believe that enough foundation was laid for some of the claims that the defense is making at this point in time.
Response, Your Honor?
Yes.
I am simply reading from Mr. Cusack's own report in that this report acknowledges that Taylor Perkins both provided an alibi as to the locations of my client on the day preceding and day of the homicide, as well as acknowledging that Blair Rollins remained unlocated. These are simply in the document.
I'm going to overrule it. I believe he's laid the foundation that he has not located Blair Rollins.
All right, thank you, Your Honor.
Sorry, I have a quick question. May I ask why we're talking about Blair Rollins? Since if I'm correct, I believe that Avery Becker is the one on trial today.
Well, yes, I'm simply trying to help the jury understand the other suspects of this case.
Okay.
Thank you. And let the record reflect that the trial technician has stopped screen sharing. Finally, Mr. Cusack, did you have any genetic evidence pointing towards Avery Becker committing the crime?
No, we had no genetic evidence except for that of the victim, Mackenzie Brackman, pointing to any suspect. However, we can reasonably conclude, due to the fact that the ring security video showed a suspect whose build and stature matched that of Avery Becker, that Avery Becker could very well have been at the crime scene that day.
But going to those ring videos, those also could not show the face of the perpetrator, their race, gender, any solid identifying features?
No, merely, as I said before, their height and build.
Thank you, Your Honor. No further questions.
Thank you. Any redirect?
Very briefly, Your Honor. Mr. Cusack, based off of your analysis of all of the physical evidence, do you believe that it's likely that Blair Rollins was a suspect of this case?
No.
No further questions, Your Honor.
Okay. Any recross based on that question?
No, Your Honor.
All right. This witness may be excused. Does the prosecution have any further witnesses?
The prosecution rests at this time, Your Honor.
Okay. Does the defense have any motions or wish to call any witnesses?
Yes, Your Honor. At this time, the defense calls Professor Blake Van Owen to the stand. Permission to, permission to proceed, Your Honor. Thank you.
Yes, go ahead.
So, good morning, Professor Van Owen. Can you please state your full name and spell your last for the court?
Good morning. My name is Blake Van Owen, Vanowen.
Thank you. And what is your profession?
I am a private investigator, a professor, and an expert witness in police practices.
And can you please tell us about your experience with law enforcement?
Yes, I worked at the Aurora Police Department for about 9 months, and then I worked as a school resource officer, then a private security guard, and then I went into private investigation.
And do you have any educational experience pertaining to police practices?
Yes, I have my master's degree in criminal justice through Ashford University. I also taught a class on police procedures at the Community College of the Rockies and a class on police practices and social justice at CU Denver.
And have you ever testified as an expert witness in court before?
Absolutely. I regularly testify as an expert witness in many fields, such as police practices, use of force, forensic evidence techniques, false arrest, crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Thank you. And which courts have accepted you as an expert?
I have been accepted as a defense expert in the U.S. District Court of the Districts of Colorado, Kansas, and Arizona, and in the state courts of Colorado, Wyoming, Nebraska, and New Mexico.
Thank you. And do you have any other pertinent experience in court?
I have been accepted as an expert in crime scene reconstruction 8 times, in cell tower analysis 5 times, and in general police investigation tactics 12 times. I have consulted on over 100 cases.
Your Honor, at this time, the defense moves to enter Professor Blake Van Owen as an expert in police practices, cell phone tower analysis, and crime scene reconstruction under 702, given her experience in those fields.
Any objection?
Permission to conduct a brief voir dire.
Granted.
Professor Van Owen, you're currently a professor of a course at CU Denver, is that correct?
Yes.
But you're not currently a police investigator?
No, but I have been, and I'm currently teaching police practices.
You only spent 9 months as a police investigator, is that correct?
Yes, but after I work as a school resource guard, which is still technically in the police force.
However, it's been quite some time since your time at the Aurora Police Department, is that correct?
But since then, I've always been up to date with the police practices and teaching classes on those.
I apologize. Is that a yes?
Yes, that is a yes.
Now, in all of your work as an expert witness, you've only ever testified as a defense witness, is that correct?
That is true, because the prosecution usually takes the police, and there's more availability in the defense for someone like me, to more jobs for me available.
Thank you. Now, you've only ever testified as an expert in crime scene investigation 8 times, is that correct?
Yes, but I've also testified as an expert in cell tower analysis 5 times and in general police investigation tactics 12 times.
Thank you, Your Honor. No further questions and no objection to the admission of this witness as an expert.
All right. And the witness will be admitted as an expert in police investigation, cell tower analysis, and crime scene reconstruction.
Yes, Your Honor. So, Ms. Van Owen, can you please tell us about the quality of the police department's work in this case?
Yes, as I have reviewed all of the police reports, the crime scene reconstruction, the cell tower reports, and the exhibits prepared by Detective Markowitz, and also conducted my own partial investigation, I can tell you that the police department did a sloppy job investigating this case.
And what makes you say that?
Kyle Cusack was obviously investigating with a subject in mind.
And what makes you believe this?
Cusack's investigation was blind to evidence that supported other, even more likely theories. Cusack even pulled pieces of narrative out of the blue with no evidence, such as the intruder stabbing Brackman with the same knife that Brackman had retrieved from a knife block in the kitchen, just to make his story more coherent.
And please allow me to direct you to what has been previously marked as Exhibit 20 and let the record reflect that the trial technician will display it. Do you recognize Exhibit 20?
Yes.
And how do you recognize it?
This is my official report analyzing the investigation done for today's case.
And did you create this work yourself?
Yes, I did.
And is this a fair and accurate copy of your work?
Yes.
And do you regularly create expert reports such as this when you testify?
Of course, it's part of what I do as an expert witness.
At this time, the defense moves to enter Exhibit 20 into evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 20 will be admitted. You may publish.
Yes, Your Honor. So, Professor, allow me to direct you to the second page of Exhibit 20. What did you report as the most likely scenario for Mr. Brackman's death?
Brackman was sitting, and the intruder behind him stabbed him, holding the knife as you can see in the picture. If Brackman were standing, the intruder would have had to be much bigger than him, which we can rule out from the ring video evidence.
And can you please tell us more about the ring videos?
Yes. While Detective Markowitz makes a big deal of the ring alerts, I also have a ring security system set up in my house, and I am aware of its pitfalls. A user can turn off push notifications, allowing an intruder to break in without the victim ever being aware. Markowitz did not collect records from Ring to check whether Brackman had his notifications on, and even if he did, he might not have had his phone on him at the time, and still would have been surprised by the intruder. Cusack just jumped to conclusions that the alerts were on.
Thank you. Now, let's move on. What can you tell us about Avery Becker's phone?
Investigators used cell phone tower data to locate the phone, despite Becker having been separated from the phone the night before.
Let the record reflect that the trial technician is displaying the fourth page of Exhibit 20. Thank you. Now, referring to this page of your report, what does this graphic indicate about cell phone tower data?
Cell tower data is much less accurate than GPS data. Since we don't have the actual phone and we have to rely on cell tower data, we can never know if the phone was ever close to the victim's home. As you can see, each tower can reach up to 6 miles in each direction.
And can you please explain to the jury just a bit more about how cell tower data works?
Cell phones have the ability to connect up to multiple cell towers. A phone is designed to connect it to the tower that provides the best signal, not the nearest tower. Cell towers also cover a very wide area, and call detail records can't record the precise location of the dozens of phones connected to a single tower at a time.
And as far as this case specifically, how was cell phone tower data investigated?
Detective Markowitz only subpoenaed the cell phone tower records for a limited window of time, so we can only know that the phone communicated with a cell tower somewhere in the area. There is no way to tell that Becker's phone made it from his house to Brackman's house just before the murder.
Thank you. And just in general, can you please tell us more about how phones were considered during this investigation?
Well, since the prosecution only had one suspect in mind from the beginning, only cell data from Avery Becker's phone was looked at. A smarter thing to do would have been to obtain cell records from all of the phones in the area and talk to anyone who had a connection with the witness or the victim. Especially important was Taylor Perkins' phone, considering that Becker was with Perkins the entire day of the murder.
Thank you. And moving on, can you please tell us more about the phone screenshots brought forward by the prosecution?
The screenshots of the messages sent to the police by Alex Cifuentes were not questioned in the slightest. It is the job of the police to be skeptical. The Denver Police Department has the tools to run examinations on cell phones that could have verified or falsified this evidence, but they just literally chose not to do the work.
So, given your expert opinion, how do you view the work done on the investigation today?
There were so many errors done on the prosecution's end. Not only did they investigate already considering Avery Becker guilty, they failed to obtain relevant cell tower records. They lost pictures of blood drops in the hallway, and the digital file containing those pictures was mysteriously corrupted. I don't suspect malice. I understand it was just incompetence.
Thank you, Your Honor. No further questions at this time.
All right, cross-examination.
Now, Professor Van Allen, before we begin, I'd like to ask that simply due to the sake of time, you refrain to yes or no answers when prompted to do so. Now, you sit here today to tell us of all the flaws in the prosecution's investigative work, correct?
Yes.
Yet, according to you, you yourself were not a perfect police investigator.
No one is perfect.
In fact, those mistakes you made actually drove you away from the line of work entirely.
It was the police and how they were accepting of such flawed behaviors that I wasn't okay with.
Is that a yes?
No, it wasn't my mistakes. It was how the police conducted business that drove me away from the force.
Now, you've chosen to make a new living out of exposing the mistakes of other investigators. Is that correct?
No, my living is made on exposing, or not exposing, but proving innocent people innocent.
Thank you. Now, it's true that you prefer to be called professor. Is that correct?
Yes, that is true.
Not detective nor investigator?
No, I have earned my professor.
You refer to yourself as a check on the power of police, correct?
Yes, that is true.
You're charging $450 an hour for your testimony in today's case. Is that correct?
That is true.
Objection, Your Honor. Relevance.
Response.
Your Honor, I believe the pay that this witness is receiving from opposing counsel can go towards their bias as well as how they handle their investigation in this case.
Response, Your Honor.
Yes.
The witness has provided no indication that her work was influenced by what she is paid, on top of the fact that she is a professional and needs to be paid for the work that she does.
Okay, I'm going to overrule the objection. He can question her on that.
Now, Professor Van Owen, you even charge up to $10,000 a case. Is that correct?
Yes, but I think everybody here, including yourself, counsel, is making money off of this case.
It's safe to say you have a pretty decent living from this line of work. Is that correct?
But that's not the reason that I do this to vindicate innocent people.
Is that a yes?
That it's not as simple as a yes or no answer.
You sit here today to criticize the lack of a complete investigation on behalf of the prosecution, yet you yourself did not complete a full investigation, correct?
It is not the burden on the defense to complete the investigation. It's the prosecution's burden.
Again, I ask that you please answer with yes or no. So is that a yes to that question?
Again, it's not as simple as a yes or no.
Did you complete a full investigation in today's case?
No, but it's not my job.
Thank you. Now, have you yourself met Mr. Kyle Kuzak before?
Yes, I have.
You believe he's a little egotistical?
Yes, I do, but I also generally like Kuzak.
You think he's a little full of himself?
Yes.
You claim that on-scene evidence points to an intruder that broke into the Brackman home. Is that correct?
Yes, that is true, but we can't be sure that it's Avery Becker.
Much of the evidence presented in today's case was found on the scene of the crime. Is that correct?
Yes.
A crime scene which you yourself never stepped foot in?
No, I didn't, but I have overlooked all of the evidence in the scene and conducted my own partial investigation.
So you've looked over and conducted a partial investigation of evidence you've never had your hands on. Is that correct?
No, but I know enough about the case to consider everything just as well as the police can.
Thank you. Now, you claim that Detective Markowitz failed in investigating in the sense that he neglected to get a full report of the victim's ring account.
That is true. There were so many missing pieces that Detective Markowitz failed to receive.
Yet in quote unquote filling in the holes of this investigation, you yourself did not obtain a full ring.
Again, it's not my job. It's the prosecution's burden.
You did not do that?
It's the prosecution's burden, not the defense.
Yes or no, please?
It's not as simple as a yes or no.
You completing a full report is not as simple as a yes or no?
Not when it's not my job.
Thank you. Now I'd like to move on. You claim Detective Markowitz failed to obtain cell tower records for Taylor Perkins. Is that correct?
Complete cell tower records, yes.
You also failed to complete cell tower records?
Again, it's not my job.
Thank you. Now, you agree cell tower records indicate Avery Becker's phone was near the house at the time of the murder. Is that correct?
We cannot tell by the cell tower records that were examined that it ever made the trip from Avery Becker's house to Brackman's house.
I'd like to confirm you're saying you do not agree that records would indicate her phone was near the house at the time of the murder?
Yes, it was, but we can't confirm it for sure that it made the trip from her house to Brackman's house.
Thank you. Now, despite a lack of GPS capability, you claim cell tower records strongly suggest that instead Taylor Perkins and Avery Becker were both at the mall in Fryshack on the day of the murder?
Well, since Detective Markowitz didn't actually collect data from Taylor Perkins' phone and Avery Becker's phone was separated from her on the day of the murder, we can't be sure.
Professor Van Owen, do you claim that is what the records indicate?
Yes.
Now, you claim those records indicate that despite their lack of GPS capability, but say at the same time, GPS capability was not there to prove the phone was at the house.
Sorry, can you repeat the question?
I'll simply rephrase. You claim that while phone records indicate the whereabouts of Taylor Perkins and Avery Becker, they can't indicate that they were at the house. It must have been at the fry shack.
I am not sure. I wasn't there. I don't know.
You failed to obtain Avery Becker's phone records to validate her whereabouts from the day before. Is that correct?
It's not my burden. It's the prosecution's burden.
It's a simple yes or no.
It's not my burden. It's the prosecution's burden.
Could you please answer the question with yes or no, Ms. Van Owen?
No.
Thank you. You failed to obtain Taylor Perkins records from the day before.
It's not my burden. It's the prosecution's burden.
You dived into an accusation of your own. Is that correct?
Yes.
An accusation of Blair Rollins?
Yes.
You even discussed the supposed motives of Blair Rollins to commit this crime.
Yes, I believe that since Mr. Brackman failed to vindicate Blair Rollins' father in a murder trial, Blair Rollins would have much more of a motive than Avery Becker ever had.
Is Blair Rollins in this courtroom today?
No, we don't know where Blair Rollins is ever since the day of the murder.
Are we here to investigate Blair Rollins?
No, the prosecution completely investigated this trial with only Avery Becker in mind.
However, we are here to investigate Avery Becker. Is that correct?
Yes, because no one even considered Blair Rollins.
No further questions, Your Honor.
Redirect?
Yes, Your Honor, briefly. Professor Van Owen, pertaining to your time with the police, why did you leave the department?
I left the department because after an incident, I realized that the police practices were way too forceful and immoral, and I did not agree with the way that the police handled things, and I did not want to be a part of that.
Thank you. And as far as how you have made money after that time with the police department, do you need to be paid for the work that you do?
Absolutely not. Well, I guess yes, I do. I mean, I need to make a living, but that's not the reason that I do this. You know, I need money to eat and to have a house, like all of us do. But I do this so that I can see innocent people walk free.
Thank you. And as far as the actual work that you do as a private investigator now, is it your job to fill in the holes that the prosecution leaves?
Yes, that is what I'm here for.
But as far as how their investigations may not be completely thorough, is it your job to really just clean up after them if they do a sloppy job?
No, I am here to point out their flaws, but I'm not here to do their job and complete their case.
Thank you, Your Honor. No further questions.
Any recross based on those?
Briefly, Your Honor. Now, Professor Van Owen, you've stated on redirect that you are here to fill in the holes of the prosecution's investigation. Is that correct?
Yes.
Yet you did not complete a full investigation or claimed it was not your job to complete a full investigation in this case?
Yes, I also claim that it's not my job to do the police's work.
Did you expect to fill in the holes of the investigation without completing a full investigation yourself?
I will claim that I filled in the holes of the police investigation by pointing out their flaws.
Thank you, Your Honor. No further questions.
All right, thank you. This witness may be excused. Does the defense have any further witnesses?
Yes, Your Honor, at this time, the defense calls Ms. Taylor Perkins to the stand. All right, permission to begin.
You may.
All right. Good morning, Ms. Perkins. Could you please state your name and spell your last for the record?
Sure thing. Taylor Perkins, Perkins.
Now, Ms. Perkins, tell us a bit about yourself.
I'm currently a freshman at CU Boulder this year, which is really exciting. I graduated from CHS Colorado High School last year, and I was on the mock trial team in high school.
And did you have friends in mock trial?
Yes, my very best friend, Avery Becker, was on the team, which was a lot of fun. I enjoyed mock trial with her.
Tell us more about Avery Becker.
Avery was the best lawyer on the A team. There is no doubt about that. I put in some hard work myself, but I was not as good as Avery. Avery didn't have to put as much work as others. Her work ethic was a little lackadaisical, which was okay because her passion for the team made up for it. But her lackadaisical work ethic did bug some other people on the team, including our coach, Mr. Brackman.
Could you tell us more about this coach?
Yeah, coach was a great guy. Him and Avery did not always get along, which in my opinion was a little childish and foolish, but the idea of their feud ending in murder in the hands of Avery, there's no way.
Could you tell us more about this feud?
Sure thing. So right before regionals, Avery was demoted to the B team, which I thought was very unfair. Although Avery didn't put in much work, Avery was the best lawyer on the team and still had passion. And I ended up stepping down in honor of Avery.
Was this a big sacrifice for you?
Not at all. Avery was one of my very best friends, and it took no convincing or talk from Avery to make me do so. This was a decision I made because it was the right thing to do for a friend and a friend that was good at mock trial.
And then were there any other examples of events that happened within this feud between Avery and Coach Brackman?
Yes, this event I wasn't there for, but Avery took what she believed to be a dry erase marker and wrote Worst Attorney Award on Coach Brackman's car.
Objection, Your Honor. Hearsay.
Fun?
I believe this isn't a statement. This is just describing an event. This isn't a written statement for the truth of the matter started. It's just explaining what happened.
response on that?
Your Honor, the witness had a direct quote that Avery wrote on the car. That is hearsay.
Okay, so I'm going to overrule as to what was written on the car. Thank you.
Moving on to after what happened after this.
So because of the incident, Coach Brackman ended up kicking Avery off the team. And I thought this was pretty unfair, but finals got canceled due to COVID anyways, so we all kind of moved on.
Backtracking to Avery's attempts to get back on the team, how did this play out?
Yeah, Avery texted Alex Fuentes and a bunch of other team members, which I was surprised. Avery texted Alex because Avery and Alex did not quite get along. And Avery went to Brackman's practice to try and appeal to him to get back on the team, which didn't work out too well. So me and Avery ended up going to the mall, doing other things, and going to the Fry Shack where Avery ended up losing her phone.
You say Avery lost their phone. What did you guys do about that?
Yeah, so we didn't realize until the next day. So the very next day we went and retracked Avery's steps. We went back into all the stores that we had been in the mall. With no luck of me calling Avery's phone, we ended up going to the Fry Shack and still couldn't find Avery's phone, but we saw some other team members at the Fry Shack while we were there.
And what happened with you and the other team members at the Fry Shack that night?
Yeah, it was kind of weird to see them there because they should have been at practice with Coach Brackman, but they said that Brackman never showed up, so they went to the Fry Shack, and I guess now we know why.
And then was anyone else gone from school that same day?
Yeah, the same day that we spent looking for Avery's phone, this other kid, Blair Rollins, who is also friends with Alex Fuentes, was missing from school. Blair's kind of like a psychopath weirdo, and quite
Objection,
honestly,
Your Honor, to both speculation and improper character evidence of Blair Rollins.
Response?
I believe that since these two went to school together, it doesn't require speculation. And because I've laid the foundation that they've gone to school together, that Ms. Perkins can testify about Blair Rollins.
Your Honor,
So
if I may respond.
Yes.
Oh. So to the speculation objection, you were not at school, Mrs. Perkins. You would not know whether Blair Rollins was also at school. In addition, you have no means to testify that Blair Rollins was in fact a psychopath, as you are not an expert in psychology. And also you are attempting to use Blair Rollins' psychopathy to indicate that she or he committed the crime, which is improper character evidence.
Right. At this time, I'm going to sustain the objection to the statement that they're psychopathic, but she may testify as to her knowledge of Blair, how she knows Blair, etc.
All right, Ms. Perkins, you may continue unless you want me to re-ask the question.
Yeah, Blair, in my opinion, was just kind of weird and friends with Alex, who Avery did not necessarily get along with. So I can definitely see Alex taking Avery's phone and giving it off to Blair.
Thank you, Your Honor. No further questions.
All right, cross-examination.
Yes, Your Honor. Mrs. Perkins, it is true that Coach Brackman was always giving Avery a hard time, correct?
That's true. As a coach, you probably always want to see your kids succeed, and Avery being a good lawyer on the team, I can see Coach Brackman trying to push Avery to be the best she could.
You would say that this feud between Avery and Coach Brackman really bothered Avery.
Yeah, having someone that you looked up to and someone that you found encouraging always being hard on you, I can see how that's difficult at times.
Thank you. I would ask that you keep your questions to a yes or no responses. That is all that it calls for. You would agree that Avery could be rash, yes?
Rash in what sense?
Avery's actions often were rash, unpredictable.
That could be found true in some people's opinion.
You state that Avery could often be rash.
Avery could often make decisions that didn't always end the best for her, but
Thank you. And this was Avery's senior year at CHS.
that is true, just as it was mine.
Mock trial meant a lot to Avery.
It did all 4 years.
And you observed that you observed that Mrs. Becker was angry about being demoted to the B team.
Of course, after 4 years of hard work, I can see how one would be upset.
Now, you mentioned a practice where everything blew up.
That is true.
It is true that Avery vandalized Coach Brackman's Porsche.
And it means that she didn't mean to do so.
But she vandalized the Porsche, yes?
That is correct.
And you observed that Avery's reason behind this was to freak Coach Brackman out.
After being after being kicked off the team, after being demoted, I can see how that's upsetting. And one might want to just blow off some steam.
Okay.
Sorry, would you repeat that?
Avery was upset. Yes, Avery wanted to freak Coach Brackman out. Yes.
Correct.
And Avery was upset when she was kicked off the team following this incident.
Of course, Avery meant it as an honest mistake, and I would be upset as well.
So Avery was more upset after being kicked off the team for vandalizing her coach's Porsche.
I would say that Avery was upset in the first place to be demoted and wanted to blow off some steam. And so being kicked off the team was just another thing that's piling onto Avery's stress level.
Thank you. You mentioned that Alex Cifuentes talked to you about Coach Brackman's unfairness.
Would you repeat the question?
Yes, at Fry Shack, you mentioned that Alex Cifuentes talked to you about Coach Brackman's unfairness.
Towards Avery, correct.
Have you ever wanted to harm Alex?
Of course not. I'm not a violent person, and I would never want to harm anyone that I was on a mock trial team with, someone I went to school with. In fact, I wouldn't want to harm anybody.
Is it true that you say in your witness statement that you wanted to punch Alex Cifuentes in the face?
Sometimes I think those thoughts, but I would never want to do it because although it's frustrating that someone could be against my best friend, I wouldn't harm them.
Did you or did you not want to punch Alex Cifuentes in the face?
In the moment, I'm not sure if I felt exactly that way, but.
Thank you. On the day of the murder, both you and Avery were absent from school.
That's true. We were looking for Avery's phone, retracing her steps at the mall.
And you weren't actually sure whether or not Avery had her phone.
We could not find Avery's phone, and with me calling it, we still were unsure of where Avery's phone was.
But you would not know whether or not Avery had her phone or not.
Well, as a friend, I would assume that Avery wouldn't lie to me and make me skip school to spend my day looking for Avery's phone if she had had it.
But you don't know for sure. Thank you. And you both forgot that you could use iCloud to easily track an iPhone.
Unfortunately, I have an Android phone, which makes the aspect of using Find My iPhone to indicate a phone's location was not accessible.
So you and Avery both ditched school on the same day that Coach Brackman was murdered at his home.
That is correct. We were not at school that day.
You never in a million years would have guessed that Blair Rollins had anything to do with the murder.
I think that Blair Rollins is a weirdo at school, and I think that Blair is capable of taking the phone from Alex, who took it from Avery.
But it is true that you mentioned in your witness statement that you never in a million years would have guessed that Blair Rollins would have done this.
I would have never wanted anyone from school or anyone to kill.
It is true that Coach Brackman was defending Blair Rollins' father in the case that he lost, correct?
That's true, which unfortunately Blair Rollins' father ended up going to prison, which I can assume made Blair
You don't
very
have
upset, as it would
any
I.
evidence. Thank you. You don't have any evidence suggesting that Alex Cifuentes made fake text messages from Avery?
That's true. I don't know much about faking texts.
Thank you. And you don't have any evidence that Alex Cifuentes even had the phone?
That is also true, but as you had guessed, that Avery
Yep.
still had
You don't
the
have-
phone.
You don't have any evidence that Avery didn't have her phone?
That's true, just as you don't have any evidence that Alex had the phone, or that Avery had her phone.
And you admit that Alex giving Blair Avery's phone sounded like a stretch?
I think that Alex taking Avery's phone and giving it to Blair is not a stretch because of the fact that Blair is kind of a weirdo at
Thank
school.
you. No further questions.
All right, any redirect?
Yes, Your Honor, briefly. All right, Ms. Perkins, why did Coach Brackman push Avery in mock trial?
Coach Brackman definitely wanted to see everyone succeed on the team, and Avery being a very good lawyer, even with low preparation, I can see how Coach Brackman wanted Avery to succeed.
Was your friend Avery capable of murder over a mock trial dispute?
Absolutely not. Avery enjoyed mock trial, and Avery being a murderer, there's no way.
Would you physically harm Alex Cifuentes at the Fry Shack over a mock trial dispute?
No way. Although it was frustrating to see my friend Avery being placed in a situation of being kicked off mock trial and losing her phone, it's easy to take out anger at someone in the moment in your head, but moving forward, I would never.
And finally, do you think about who would be capable of killing who at school in a normal situation, such as Blair Rollins? Was it a surprise? Because you typically don't think about who is capable of killing who at your school.
I don't ever want to look at the kids at school and think, oh, they're a murderer, or ever place that on someone in my head. That's a situation that I don't think any of us want to be here for. And unfortunately, it's happened. So it's sad to think that someone from school may have.
Thank you, Your Honor. No further questions.
Right. Based on those, do you have any recross?
No, Your Honor.
All right, this witness may step down. Does the defense have any further witnesses?
Your Honor, at this time, the defense calls Avery Becker to the stand.
All right, and Mr. Becker or Ms. Becker has taken the stand, and you may start questions.
Please state your name and spell your last for the record.
My name is Avery Becker, spelled Becker.
Ms. Becker, why are you in court today?
I'm here today in court because I am being wrongly accused of murdering my former coach, Mackenzie Brockman.
Could you be a little bit more specific about who Mackenzie Brackman was to you?
Yes, he was the coach of the mock trial team that I was a part of for 4 years while I was at Colorado High School.
And what was your relationship like with Mr. Brackman?
To be honest, we definitely did not have the best relationship. We would fight about my perceived work ethic and my perceived preparedness, which Mr. Brockman believed was slightly lackluster.
And how did Mr. Brackman criticize your work ethic?
Both verbally with hurtful and humiliating comments, and also the action of demoting me from the A team to the B team.
Ms. Becker, can you describe this demotion in a little bit more detail?
Well, I came to practice just like any other day, and as soon as I got there, Mr. Brockman started ripping into me like he often does, and told me that I was once again unprepared and that this was the final straw. So he kicked me down
Your
to the
Honor,
B team.
hearsay.
Response?
Your Honor, this evidence is not being used to prove the truth of the matter asserted. It is simply stating what happened between the two during this event.
Okay, I'll overrule the objection.
Would you like me to repeat my question?
I believe I said what I needed to say, so we can move on.
Okay. And Ms. Becker, how did you make it back onto the A team following this incident?
Well, my best friend Taylor Perkins took it upon herself to step down from the A team in order to open up a position for me to get back on the A team. So that's exactly what happened. A week before the regional mock trial tournament, I was reinstated on the A team.
And Ms. Becker, how did you perform at the regional tournament?
As well as I expected and hoped. I won the Best Attorney Award and was named Best Closer.
How did Mr. Brackman react to these accomplishments?
Well, you'd think he would be proud of my accomplishments and would see that I earned them, right? Wrong. In fact, he told me that I did not deserve these awards and that I had simply relied on my good looks. Objection, Your Honor, hearsay.
In response?
Once again, Your Honor, I'm not using this evidence to prove the truth of the matter asserted. It is simply recounting the events that happened after the regional tournament.
I'll overrule. You may respond.
Ms. Becker, do you need me to repeat my question?
Yes, please.
How did Mr. Brackman react to these accomplishments?
Well, like I said before, you'd think that he would compliment me on my accomplishments and be proud of me, but this was not the case. In fact, he went so far as to say that I did not deserve the awards that I won and that I simply relied on my good looks and natural abilities to earn these awards.
And Ms. Becker, how did you react to these comments?
Well, I was obviously very hurt and upset by these comments, so I wasn't going to continue to take these hurtful comments without doing anything, so I stormed out of practice.
And what happened next?
Well, when I got outside, I saw Mr. Brockman's obnoxious white Porsche, and in the moment, I was so upset with him for saying the things that he had, that using a pen that I still had in my hand from practice, I wrote across the hood of his car, "Worst Attorney Award."
How did Mr. Brackman react when he saw this?
Well, understandably, he was very upset and angry, and he immediately kicked me off the mock trial team.
And Ms. Becker, how did you feel after this incident?
I felt horrible. I tried to apologize in many different ways and was never able to, which makes this all the more devastating, seeing as that was never able to happen.
Now, moving on to March 6th, the day of the murder, where were you on March 6th?
The entirety of the day of March 6th, I was with my best friend, Taylor Perkins, and we were searching for my lost phone.
Ms. Becker, what happened to your phone?
I believe I lost my phone on March 5th, the day before, at some time while I was at either the Fry Shack or the mall.
And where did you last see your phone?
The last time I can vividly remember seeing my phone is at the Fry Shack, and it was sitting on a table where Alex Cifuentes was also sitting at.
Now, just to clarify, you were not at Mr. Brackman's house on March 6th?
Absolutely not. Before this case, I had no idea where Mr. Brackman lived, and there is no way I could have been at his house because of this fact.
At this time, Ms. Becker, I would like to direct your attention to Exhibit 14, the text messages which have been previously entered into evidence. Let the record reflect that the trial technician is screen sharing what has previously been marked as Exhibit 14. Ms. Becker, have you ever seen the text messages depicted in these screenshots before?
No, I have never seen these text messages before, and considering that they seem to come from from Alex Cifuentes, it is quite presumptuous to assume that I would ever text Alex Cifuentes, considering we were not friends, nor did I trust her.
Let the record reflect that the trial technician has stopped screen sharing. Ms. Becker, what kind of person is Alex Cifuentes?
Alex Cifuentes is the kind of person you would never want to be friends with, nor would you ever trust, especially in this instance with the text messages that are so personal. Objection, Your Honor, more prejudicial than probative.
Response?
Your Honor, the witness is testifying as to what she believes is her relationship with Alex Fuentes and why she would not be friends with that type of person?
On the 403 objection, I'll overrule.
Ms. Becker, do you need me to repeat my question, or do you believe that you have sufficiently answered the question?
I believe I've sufficiently answered, so we can move on.
And why is it that you believe this is the type of person Alex Fuentes is?
Well, considering that we were on a mock trial team together, so we did spend a little bit of time together, I did know her sort of okay. So I believe that is how I can make these judges of character.
And what was your relationship like with Alex on the team then?
Well, on the team, we were definitely competitors and quite evenly matched. I simply got better roles on the team because I did have a year more of experience than Alex. However, if I had not been there, Alex would almost certainly have gotten the roles that I had.
Ms. Becker, if you're not friends with Alex Fuentes, then who is?
To my knowledge, Alex Fuentes is friends with a shady girl at our school named Blair Rollins.
And what is Blair Rollins' relationship with Mr. Brackman?
Well, interestingly enough, Blair Rollins' father is currently in prison for the rest of his life. And this sentence was a result of a trial in which he was represented by my former coach, Mackenzie Brockman.
Objection, Your Honor. It's been unclear how the witness would have the knowledge of this case, and I don't believe enough foundation has been laid.
Response?
Yes, Your Honor, this trial is a matter of public record, and therefore the witness could have knowledge on the results of the trial.
I will overrule it with the foundation that was just laid out by defense counsel.
And lastly, Ms. Becker, where is Blair Rollins?
I have no idea where Blair Rollins is, nor do I think anybody does. I know my attorneys do not know where Blair Rollins is. At this time, she is still missing.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. Good morning, Ms. Becker. Before we begin, I would just like to ask that you try to keep your answers as brief as possible, a yes or no, due to time constraints today. So you believed you were one of, if not the most talented members of your mock trial team?
Yes, that is my belief.
And you also believe that your old coach, Mackenzie Brackman, had a hard time accepting your natural ability?
Yes, he did have to work harder for his accomplishments than I did.
And he also criticized your work?
Yes, constantly.
He believed that you had a bad work ethic?
Yes, he did.
And that you were never prepared?
These are his beliefs. They are not actual reality.
But for these reasons, he moved you down to the B team before regionals?
Yes, these are the reasons.
And this upset you?
Yes, it was upsetting to have my 4 years of mock trial go down the drain by being demoted.
You believe that the B team was full of losers?
I believe losers in the literal sense, in that they did not perform as well as the A team, so they lost the A team.
However, your exact words were that the B team were full of losers, correct?
As I just explained, that is what I meant by that comment.
So this is a yes.
It is exactly how I just answered.
Okay, and so to fix this problem, your best friend, Taylor Perkins, quit the team so you could take her spot, correct?
Yes, we are very close friends, and she took it upon herself to do me this favor because mock trial meant more to me than it did to her.
So after you were moved back up to the A team, you had a successful regional tournament, correct?
Yes, I won the Best Attorney Award and was named Best Closer.
However, Brackman was still not content.
No, in fact, he said I did not deserve any of these awards, which was very hurtful.
And this made you very angry.
Yes, I was very upset and hurt by these comments.
So angry, in fact, that you took a black Sharpie and vandalized Brackman's white Porsche, correct?
I would like to clarify that at the time, I believed the marker to be a dry erase expo marker that could easily be wiped off. But yes, that did occur.
And then you got mad when Brackman had an explosive reaction to you vandalizing his car?
I understood, in hindsight, I understand his reaction. However, in the moment, I was still upset from his comments. So yes, I was angry.
And then you went home and told your mom that Brackman followed you out of practice and kicked you off the team for seemingly no reason?
Yes, once again, I was still very upset in that moment, and I did tell my mother not quite the entire story.
And you also told her that you would get back at him if it was the last thing you did.
I would like to clarify that in that comment, I meant that I would prove to Mr. Brockman that I deserved to be on the A team and that he needed me for state, not in any way that you seem to be implying.
All right, so on March 6th, you claimed you were with your best friend Taylor all day?
I was with my best friend Taylor Perkins all day.
And Taylor is the only one that can vouch for this, correct?
To my knowledge, however, there are cameras at the mall and at the Fry Shack that I'm sure could be checked.
So your best friend is the only one who can testify to your alibi for the murder of your coach, Mackenzie Brackman?
The only person, as I just mentioned, I'm sure there are cameras that can place me at the mall and at the Fry Shack on March 6th.
No further questions, Your Honor.
All right, based on those, are there any redirect?
Very brief, Your Honor. Ms. Becker, what were your emotions when you said you would get back at Mr. Brackman?
I was very hurt in that moment. And when I said those words to my mother, as I mentioned before, I meant that I was going to prove to Mr. Brockman that I deserved to be on the A team and that I deserved to go to state with the team and that he needed me, not that I intended to harm him in any way, shape, or form.
Thank you, Your Honor. No further questions.
And any further recross?
No recross, Your Honor.
All right, at this time the witness may step down. Defense, do you have any further witnesses?
At this time, the defense rests its case, Your Honor.
All right. Are we ready for closing arguments?
Yes, Your Honor. I ask that any remaining time be left for rebuttal as well.
That will be granted. Prosecution, would you like to give a closing argument?
Yes, Your Honor. May I please the court? Half-hearted, hypocritical, and a hole-filled alibi. Your Honor, members of the jury, today you've learned of the events of March 6, 2020, and have heard a case from the defense defined by these three phrases. Today you heard the story of Avery Becker and the anger that led her on March 6, 2020, to drive to the home of her old mock trial coach, Mackenzie Brackman, and not only to attempt to break in, but get into a struggle with and stab Mr. Brackman in the shoulder, eventually ending his life. As you heard from Alex Cifuentes, text messages and interactions were had between Alex and Avery Becker that clearly indicated Avery's motive to commit this crime. Kyle Kuzak indicated that he could in fact confirm the investigation made by Detective Jordan Markowitz, and he too stated that Avery Becker was the one to commit this crime. Detective Markowitz broke down his own investigation, both at the crime scene and through the call data records that he received, in order to confirm that Avery Becker was the primary suspect and did in fact commit this crime. Half-hearted. As you heard today in the cross-examination of Professor Blake Van Owen, the professor did not take all of the necessary steps and precautions to make a complete investigation that she claimed the prosecution was lacking. Failing to obtain call records, ring video records, and never visiting the crime scene herself revealed her lack of effort to complete a full investigation. While you heard that the professor was here to fill in the holes of the prosecution's investigation, it was apparent she intended to do so without any kind of investigation of her own. You heard on cross-examination that Professor Van Owen believed it simply wasn't her job to investigate and fully investigate many aspects of this case, meaning she's being paid $450 an hour to sit here and jump to conclusions of her own. Unfortunately, on the sinking ship, which is in fact the defense's case, pointing out the holes simply isn't the same as filling them in. Hypocritical. Professor Blake Van Owen and the rest of the defense have tried to paint the picture of an incomplete investigation, yet failed to complete a full report themselves. Not only is Blake Van Owen hypocritical in her profession and criticizing investigators following her own mistakes, but she admitted to missing some reports and data which would have made her own investigation complete. When Detective Markowitz and Kyle Kuzak spent time at the crime scene, meeting with witnesses and suspects, and completing an overall thorough investigation, Professor Van Owen sat back, picking and choosing which pieces of evidence fit her own narrative, a narrative in which she jumps to a conclusion of her own, claiming Blair Rollins was the one to commit this crime. But I'll remind you, members of the jury, Blair Rollins was not the one that we are investigating here, and Blair Rollins is not in this courtroom with us today. It's Avery Becker. Lastly, a hole-filled alibi. Opposing counsel has made an attempt to establish an alibi for the defendant, one in which, from the beginning of this investigation, Miss Becker coincidentally lost her phone the day prior to the death. While this story may appear plausible, it seems rather odd that the apparent search for the phone also happened to occur along the same cell tower path that would have led Avery Becker from her own home to that of Mackenzie Brackman. Furthermore, the defense has yet to bring to you, the jury, anyone who can attest to the alibi of Taylor Perkins and Avery Becker on March 6th. No one in this courtroom testified truthfully to having seen the two searching for Avery Becker's phone, or even seeing the two together on the day of Mackenzie Brackman's death. As the prosecution, we today have the burden of proof, meaning we must prove to you beyond a reasonable doubt that on March 6th, 2020, Avery Becker unlawfully, feloniously, and knowingly broke an entrance into, entered, or remained unlawfully after a lawful or unlawful entry in the dwelling of Mackenzie Brackman, which is located at 444 South Flower Street, with the intent to commit therein the crime of criminal mischief. And during the course and furtherance of that crime, the death of Mackenzie Brackman was caused by anyone. If you, the jury, find this to be true, based on the overwhelming evidence that Avery Becker has against her today, you must in fact find Avery Becker guilty on the counts of second-degree burglary of a dwelling and murder in the first degree. Thank you.
Thank you. Defense closing argument?
Yes, Your Honor. May it please the court. Your Honor, members of the jury, and opposing counsel. My name is Raina Hilden, and today, along with my co-counsel Cindy Nguyen and Maggie Holland, we have had the honor of representing the defendant of today's case, Avery Becker. At the beginning of this trial, my co-counsel Cindy Nguyen reminded you that the prosecution carries the burden of proof, meaning that they must prove beyond a reasonable doubt that Avery Becker is guilty. However, in this case, members of the jury, we find not only reasonable, but substantial doubt because the prosecution jumped to conclusions and ultimately fell short. We find that their physical evidence has absolutely no way of connecting Avery Becker to the perpetrator. The investigation showed that, yes, a perpetrator broke into the home of Mackenzie Brackman on March 6th, 2020, and Mr. Brackman, after tragically, was murdered. However, the prosecution failed to prove that that perpetrator was Avery Becker. The ring videos that showed the perpetrator entering the Brackman residence could not show a single identifying feature of the perpetrator. Kyle Cusack testified himself that there was no genetic evidence as to the identity of the perpetrator. And finally, the prosecution lost images that were part of the crime scene. And while they claim that those were not important to the case, we cannot know that. We do not have all of the evidence with us in the case, adding even more doubt to their arguments. With this lack of physical evidence, we very clearly see that the prosecution jumped to the conclusion that Avery Becker was the perpetrator despite an utter lack of proof. Not only does their physical evidence fall apart, but so does their circumstantial evidence. The prosecution entirely ignored the alibi given by Taylor Perkins, an alibi which, members of the jury, was acknowledged in Kyle Cusack's own expert report. Avery Becker and Taylor Perkins were together the entire day of March 6th, searching for the lost phone. Now, moving on, the screenshots brought forward by the prosecution, supposedly a conversation by Avery Becker and Alex Cifuentes, claimed to show a motive. However, Avery Becker said herself that she had never sent those texts and that she did not trust Alex Cifuentes. We saw in the investigation that the prosecution did not verify that those screenshots were authentic, and we cannot trust those as a piece of evidence. Yet another piece of doubt. Finally, a suspect with an even greater motive, Blair Rowlands, disappeared from the state of Colorado after the crime. However, the prosecution did not pursue Blair Rowlands in their investigation. They only investigated our client, Avery Becker. Members of the jury, please consider what you have seen today. In the lack of physical evidence in our client, we find reasonable doubt. In the ignorance of the alibi given by Taylor Perkins, we find reasonable doubt. And in the disappearance of Blair Rowlands after the crime, we find an incredible amount of doubt as to the prosecution's argument for the guilt of our client, because they jumped to conclusions and fell short in the end. If even one of these pieces of reasonable doubt is proved to be true, which we have shown through our arguments today, you, the jury, cannot convict Avery Becker, an innocent high schooler, of a crime she was wrongly accused of. Avery Becker herself testified today that she only intended to prove her worth to Coach Brackman and that she would be useful to the team. She wanted to prove her worth and get back the position on the team she had loved for 4 years, not intending to kill him. That would absolutely not benefit her in any way. Members of the jury, please remember that the prosecution has failed to prove beyond a reasonable doubt that our client is guilty through a lack of evidence and ignorance of the facts of the alibi and the disappearance of a much stronger suspect. And for that, we ask that you return with a verdict of not guilty. Thank you.
Thank you. And rebuttal?
Your Honor, can I quickly get a time check? 40 seconds. Okay. Jumping to conclusions. That is the phrase that opposing counsel has tried to place in the minds of you, the jury, in today's case. However, don't look through the fact that the defense is the one jumping to conclusions of their own. While the defense points the finger at Blair Rowlands, an individual not anywhat associated with this case, the prosecution completed a full and thorough investigation, which the defense lacked, which proves that not only did Avery Becker have the motive and ability to commit this crime, but did in fact commit this crime beyond a reasonable doubt. And for that reason, I ask you, the jury, to return with a verdict of guilty. Thank you.
All right, thank you. At this time, this round of mock trial has concluded. So thank you all very much. The first thing I'd like to do is allow the judges to go ahead and enter those scores and send that to our appropriate liaison. And then if we want to stick around, I don't want to keep you on too much, so you have a good break between now and your next round, but we're happy to provide some feedback. I do think, though, the scoring panelists need to go ahead and fill out their final scores and send them. And then we can engage in feedback.
I have sent my scores in. And I apologize to everybody, but I have to leave here pretty quick for an appointment. So can I congratulate both sides right now?
Yeah, if you want to go ahead, since you've sent your scores in, you can start us off.
I've done about a half dozen of these in the last few years, and I will tell you, this is the most prepared I've ever seen two teams, period. It was extremely obvious the amount of work you've done. I'll tell you, as to the prosecution, your theme came through. I apologize, I don't have it memorized, but I did write it down. And you did well, not only staying with your theme, but addressing all your questions with this theme and doing your opening and closing with it. The defense really did a great job of pointing out the holes. I mean, my goodness gracious. You guys, the amount of work you did is outstanding. If I had one comment to both sides, I would say, don't be afraid of answering questions yes or no. I don't know how much of it is, kind of gamesmanship in this setting, but you, as well prepared as you guys are for your attorneys, you're going to be able to bring out the points on redirect that you may have felt like you lost with a yes or no answer. When you explain things away and give reasons away, you sometimes lose a little credibility as a witness. So don't be afraid to say yes, and don't be afraid to say no. You make the attorney that is doing your direct examination repair anything they feel that needs to be repaired on redirect. But what an outstanding job you guys did. Just outstanding.
Awesome, thank you. Mr. Laird, do you want to go ahead and give any feedback or comments?
Sure. Thank you first, because from my perspective, it's just wonderful to see younger folks getting so engaged and doing such a great job. And I actually learn a lot watching you guys, because I'm usually where you are. And so it's neat to see it from this perspective, and it teaches me what works and what doesn't. I want to congratulate first the witnesses. I just thought the witnesses, all of them, did a wonderful job. You kind of fought back on some of the yes or no questions. I agree with that. But in terms of your preparation and your presentation, I thought it was just fantastic. You all obviously knew your facts really well. I'm just going to kind of jump around very, very quickly here, starting with openings. I thought you both did a good job. Miss Ross, you didn't talk too fast. I would, it's tough because you didn't have much time, but I would try to set the stage a little bit more. But again, you didn't have much time, but you did a very nice job. Miss Nguyen, good use of the hands and good recovery from, you had a little interruption there, and that was a good recovery. Mr. Decker, on your witness examination on direct, you had really actually on the cross you had some great objections on the cross, and you had a really good redirect. Ms. Holland, you did a nice job on that witness as well. Mr. Cruiser, on your direct examination, I would just ask for you to speak up a little bit, but you did a great job walking the investigator through the evidence. It really was understandable. Ms. Nguyen, on your cross, great objections. I thought you could have controlled the witness a little bit better, because the witness was kind of going sideways on you on that initial cross-examination. But you recovered from that a little bit, and you started to pin him down a little bit more. But there was one question that you asked that you didn't get an answer to, which was along the lines of, are you 100% sure that Avery sent the text? And he was fighting you a little bit on that, and I would have just pinned him down because you almost had him there. But that was really good. Mr. Cruiser, on the defense witness, first one, great job on the voir dire, very strong cross. You interrupted the witness at one point, which I can understand why you were, but it doesn't come across well to the jury. So that was my only comment there. Miss Hylden, very strong presence. You're very easy to listen to. And you did a very good job of raising doubt on that first cross-examination of yours. And on your first defense witness, again, good job walking the witness through the analysis. I did feel like your witness, although she was paid a lot of money, apparently she, to me, kind of carried the day. And I'm just going to skip to the closings here. I'm sorry, I just don't want to take up too much time. Everybody did a really good job on the closings, easy to follow. all in all, you guys just did a great job. I'm not trying to give anybody a short shrift here, but I just don't want to take up too much time. So really, everyone should really be very proud of themselves. You guys did a great job. You obviously put a lot of effort into this. So the legal profession has a bright future because of you guys. Thank you.
All right. And obviously feel free to jump in if you have any questions. I'll give my feedback. So again, my name's Kelly Schulten. I am a public defender, one of the supervising public defenders in Jefferson County. And so I do a lot of trial work, except for the last year for obvious reasons. And I spent years on mock trial teams. I was on the mock trial competitive team in law school. We had one in college. Sadly, back when I was in high school, we didn't have mock trial. And so to say that I'm impressed with the levels that you're at is just an understatement. I mean, you are, all of you did an excellent job. I mean, I saw no significant difference between your presentation of the case and quite frankly, the law school mock trial that I just volunteered for a few months ago. So all of you, I agree wholeheartedly that every single one of you would be excellent to the legal profession. And hopefully that's where you choose to go. So just a couple of things